So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again. So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do, okay? The agreement on these were for a 10-year deferred on those 2 aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports? Or the report? Are there any additions or corrections? So I don't know about all this. Not real sure I want to go along with this plea agreement. Mr. Johnson?
Yes, ma'am. I promise that I'll do right this time.
This time?
Yes, ma'am.
You have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, and you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when they... You're lucky you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better.
Yes, ma'am.
You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to...
That's an understatement, don't you think?
Yes, ma'am. I understand.
I appreciate too that you're being honest with me today.
Yes, ma'am.
But I have to look out for the community as
Yes,
much
ma'am.
as, you know, I kind of have 2 things I've got to do here. Figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this and I need to get my stuff together. And
Yes.
do you have people, I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, ma'am. Listen, I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you,
Yes, ma'am.
especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right?
No, ma'am.
Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily,
Yes, ma'am.
and find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here. Okay? And so here's something that's very important though. You have a handful of write-ups in our jail.
Yes, ma'am.
I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF.
Okay. You said how long ISF?
It's a 90-day program. Okay? So you've got two separate things going here. Now you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker. All right? Good luck. Take advantage of this opportunity. What? Oh, okay. Gerson Mendoza. Mr. Lewis. Sorry. I'm sorry, I didn't realize you were here. Y'all let us know as soon as those are ready, and I'll try to get you out of here. And Ms. Burge, if you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, ma'am.
Thank you. Good morning. Are you Gerson Mendoza? And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with?
No.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter?
No.
And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal?
No.
And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding?
No.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
¿Entiendes?
No.
Yes, ma'am.
And state tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond based on the nature of the...
The history is young age, he's 18 years old. Just was several classmates that was less,
I can't hear you.
I think he was less culpable than the other defendant. There's a co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says. All right, so you can go back with the bailiff. Thank you, Ms. Bursch. Deontay Reed, it's a sentencing, Mr. Lewis.
Yes, ma'am.
You can tell he does
To a full comprehension.
enough. Yeah.
Yes, ma'am.
Yeah. I'm glad you came because especially with something like this, you don't want there to be any miscommunication.
Exactly.
Good morning. Are you Deontay Wayne? Or Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838, entered a plea of guilty to the state jail felony offense of theft of a firearm. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, Judge.
State has, Judge, I suspect it's something on page 1 of the court.
I-
I have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this, as far as his assessment accountability and for his admission, to this offense. At that time, I could tell you, Judge, after speaking with him, he understands the issue with that, as far as his making a decision to try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining it to him that way, he's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at that time.
So you either did it or you didn't do it. And so if you did it, then you're getting a great opportunity. If you didn't do it, then that's what juries are for, and that's why you would go to trial. So did you do it or did you not do it? Okay, and do you want me to go forward with this? So what happens is you're gonna be spending some time with probation. And you've got to be honest with them the whole time you're on probation. They're there to help you. And so if you try not to take responsibility and try to diminish things that you're having issues with, then you're going to end up right back in here and looking at going to prison. So it's very important that you're open and honest with them. Do you understand?
Yes, ma'am.
Okay. All right, then, any reason not to go forward with sentencing?
Not real estate.
All right, Mr. Reed, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for $1,000. You will also be ordered to pay
Is that probation for 5 years?
5 years.
What did I say?
For $1,000.
It's been a long morning. Y'all are all like, what is happening to her? Okay. You're going to be on probation for 5 years. You're going to be ordered to pay a $1,000 fine. I was reading faster than my mind was going. You're ordered to pay $1,500 in restitution also, and to follow all of the rules and conditions of probation. If you do that, this is a good opportunity for you because you're going to be able to serve that 2-year sentence while you're out on probation instead of in state jail prison. The other side of that, though, is if you violate any condition of probation, you'll be right back in here and you'll be looking at that 2-year sentence that you've already agreed to. Do you understand? There's going to be, I want you to get your GED is going to be ordered for you to get your GED. That's to help you so you can get better jobs and do better things. There will be mental health treatment if you need any kind of issue. Everything that they offer you and tell you need to do is ordered. And so you're required to do that. And it's all meant to help you. Okay. So you're welcome. And so I'm handing you somewhere the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Yeah, I think I'm out of my words. I think I ran out of words the very first thing I did this morning. That's the whole problem today, is that got me off my game. Desmond Jones, Mr. Lewis. Because I keep thinking about it and how I'm going to handle that. I'm not done. I don't think I'm done. I could tell as soon as I did something, everybody's face went. What's she talking about? Good morning, sir. Are you Desmond Jones? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Jones, in cause number 250610, you're charged with the state jail felony offense of unauthorized use of a vehicle. That's from March 28th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. Ms. Holmes, you've got Tilia Mills.
Yes, ma'am.
Thank you, Mr. Lewis. Have a good day.
Thank you, Judge.
You okay over there? Good morning. Are you Tilia Mills?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Mills, in cause number 240549, you're charged with the state jail felony offense of theft with previous convictions from November 4th of 2023. The indictment alleges you were previously convicted of theft July 14th of 2022 on 2 different cases on that date in Montgomery County, Texas. And then after those were final, you were convicted 2 times on June 21st of 2023 of theft in Harris County, Texas. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mills is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. You can go back with the bailiff.
Okay, this one.
Renesia Segura, Ms. Holmes?
Yes.
I feel like they've just lots of work. Oh, this is an NTRP.
Hand it off.
Good morning. Are you Renesia Segura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Segura, in clause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions. And that was a 2-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, and that you were at a location, you were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm gonna real quick look back at the pre-sentence report to see that, all that, the criminal, how many we've got.
A lot, and I won't say it.
Oh, yeah, no. I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
I'll say I told you so when I go down the offer. Because I have a note on my file that I argued for the full 15.
Well, then I don't, then why? Then throw it back in my face.
Well, I didn't want to on this one.
Well, it deserved it
They
though.
gave her like 30 days time served.
But that's Harris County. They give 30 days time served on aggravated robberies.
They do like,
I mean,
they do 45.
that doesn't count. That's not,
They do 45.
absolutely. When there's something like that, no way. Okay, Jalen White.
So the offer, we're unagreed on the type of probation. So
Okay.
State's offering straight, we're asking for deferred.
So it is an agreement with regard to probation, just not the type. Okay, thank you. All right, so are you Jalen White? And will your client waive the formal reading of the
It
indictment?
will, Your Honor.
Let me get to it. Mr. White, in cause number 24-0038, you're charged with a third-degree felony offense of possession of a prohibited weapon from July 7th of 2023. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am. I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it's my understanding that you have reached an agreement that I would give you a probation, but it is not agreed to the type of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. White is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Ms. Holmes. She'll present it to me on your behalf when we come back. Did you have something?
Yes, Your Honor. I anticipate there will be at least one witness, a short witness at the sentencing.
Okay.
And a video as well, a short video. I don't know if we just need a little bit more time than ordinary.
Let's just, we'll do it at 11.
Okay.
That way, y'all have plenty of time.
Yeah.
And, Your Honor, since this is a probation offer, although we're unagreed on the type, would the court consider reduction of bond?
State's opposed to that, Judge. The alleged weapon that was possessed by this defendant was outfitted with a Glock switch. Actually, I don't want to speak. I know it was outfitted with a Glock switch. I think there was also 2 weapons that were involved in this entire occurrence.
Well, let's see. How old are you, Mr. White?
23.
There were 2 weapons involved, one of which was outfitted with a Glock switch, Judge.
Typically, on a probation offer like this, I would be inclined to do that. However, with the type of offense and the age of Mr. White, there's the possibility, like I have been on a lot of these young ones, that I will consider something like ISF, depending on what that pre-sentence report shows. And based on that, at this time, I'm not going to reduce that bond. Okay, you can go back with the bailiff. On Segura, I'm printing a PC on that Wilkinson. And is there a order for the bond, for the All right, are you Dylan Wilkinson? And Mr. Wilkinson is charged in cause number 250260 with deadly conduct, discharging a firearm. And Ms. Holmes has filed a motion asking that I reduce the bond, which is currently set at $100,000. There was a non-appearance, is that correct? A bond forfeiture for non-appearance.
And that's what we'll address here, because he bonded out in Smith County, so he actually did post the bond, but Jefferson County apparently didn't get word of it. So he was in custody in Smith County, posted bond, but still had the warrant here. And so when he came to Jefferson County, he was rearrested. And then it was set at 100,000.
But I show there was a bailiff's call. There was a court date set. Yeah, there was a court date set that, on May 19th of 2025. There was a court date and a bailiff's call, and he was not here.
Per the bondsman, after I had spoken to her, she said, basically, she told me on the ISTC phones there at the jail when I got arrested this time, she said that Jefferson County was highly pissed I had gotten, I was able to make bail, and that for 4 months that they had not known that I was out on bail. And then she said I needed to take care of the stuff in Jefferson County and that she was no longer my bail bondsman. And that was the last time I spoke to her.
She doesn't get to say that, so,
But,
but that's why you probably didn't get
that's what she
notice of it. This is from a Big Green bail bonds
That's the woman I had spoken to.
in Tyler.
Yeah,
Okay,
Because I wasn't sure
yeah,
why.
that's Smith County.
I wasn't
Texas.
exactly sure why I was rearrested again. And she never really could give me a straight answer.
and she never told you about a court date.
No, ma'am. And you're saying I had a court date on what date you said?
May 19th.
This one might have been the court date.
What were you arrested for in Smith County?
The charge from here.
That's what he turned himself in Smith County, thinking he posted the bond, but
Okay.
I don't know.
And the initial bond that they set, I guess, did
It was
they set it or did I?
10,000.
They said it, there.
It was 10,000. Let me read this real quick. They also did file an AFRS to get off the bond. But the bond forfeiture overrode that, so that might be why she. For everyone's information, I'm reviewing the probable cause affidavit, which obviously makes me have some concern on what the allegations are that you did. So where do you live?
I'm going to be staying with my mother.
With your mom?
Yes, ma'am.
Where's that?
One street over for Brinkman Drive in PA.
In Port Arthur?
Yes, ma'am.
What is the address?
3965 13th Street.
396532.
And what is your mom's name?
Monica Osman.
What's his last name?
Osman, Ozmun.
Is there any criminal history that you know of?
There's a misdemeanor DWI conviction and a very extensive juvenile history from Henderson County.
Okay.
Several adjudications for unauthorized use of a motor vehicle and burglary vehicle.
And I believe those were over 10 years ago.
It can't be that long ago because he's only,
He's 25.
okay.
I think they're
Yeah.
around 2015.
Okay.
And the complainant, is my understanding, she doesn't live here. She lives in the reports that state she lives around like the Dallas area, like Kemp, Texas. Where is that? I think that's up near the Dallas area.
Okay.
There's two complainants.
Yeah.
Oh,
There's one here and one there.
Yes, Your Honor.
but the girlfriend lives up near the Dallas area.
Haley Murph.
Yes, ma'am.
When's the last time you had contact with her?
It's been at least 9 months to a year. I haven't spoken to her since well over last year. I don't know whereabouts on where she's at. Last time I've heard anything, someone had told me that she was engaged and moving to Colorado.
Second. And do you know this Samantha Grant?
No, ma'am, I've never met her before.
Mr. Nichols, what's your position?
Whatever the court decides as far as the bond, I just ask that it be sufficient to make sure he appears. I'll let the court know there's some cooperation issues with the girlfriend of the victim, but I have seen nothing to concern the other victims, so I intend to push this case forward, Your Honor.
Okay. All right, so here's what I'm going to do. Mr. Wilkinson, I'm going to grant the motion to reduce your bond. I'm going to reduce your bond to $30,000. If you make that bond, there are several important conditions of it. The first is that you have absolutely no contact, no communication in any way. That's obviously in person, but it also means through social media, sending messages through other people, anything like that, with either Haley Murph or Samantha Grant.
Yes, ma'am.
Also, you are going to be ordered as a condition of that bond to live with your mom, Monica Usman, at 3965 13th Street, and that is the only place you can live. You cannot move unless you ask my permission. You're also going to be required to wear a GPS monitoring device at all times and remain in Jefferson County unless you have my permission. Do you understand that as well?
Yes, ma'am.
All right, any other conditions or?
I think that'll do it, Your Honor. Thank you.
Yes, ma'am, if you can.
Okay, so he does have a job that requires travel, Your Honor. How would that work as far as, do we need to
I need
contact the
this.
court?
Yep. I want specific information about, you need to get that to Ms. Holmes. And so if you make that bond, a couple things will happen. One, if you make the bond, you need to know now that you will be required to at least try to hire your own lawyer. So that's something you'll need to keep in mind. Ms. Holmes will stay your lawyer unless that happens. But as soon as you get out, if you have a job that requires travel, you need to let her know, employer, get something in writing, where you go, things like that. She'll get it to me through a memo with Mr. Nichols involved in it, and then I'll say yes or no to that. You cannot leave unless you have my permission, so you've got to stay in touch with her. She gets to me, and then you'll see if you, and I mean, we want you working. I just need to know where and what the company is and all that kind of stuff. Okay?
Yes, ma'am.
All right, you can go back with the bailiff. All right, and- yeah, okay. Okay, Mr. Nichols, Mr. Franklin, on Juan Sanchez. Good morning. Morning. Good morning.
Good morning.
All right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree with
So-
you. I don't know that subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May.
Right.
I don't have anything really responsive to that
Okay.
at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards
Right.
getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
the
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah,
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, is there, or do you have any concerns you want
If there's,
to make the court aware of?
Your Honor, just with the clarification of
Our departmental chronologicals, which include, anything that pertains to the case that happens, chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
Well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get,
Right,
that's great. Everybody can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your-
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Be needed?
I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing.
And that brings this courtroom session to a close. But the real question is, what happens next? The judge has made the consequences crystal clear. Second chances come with conditions, and breaking those conditions can completely change the outcome, from probation violations to strict release terms. Every decision in this courtroom carries weight. So what do you think? Did the judge make the right call? Let us know in the comments. And don't forget to like, subscribe, and watch the next case for more courtroom moments you won't want to miss.